I like to look at things as simplistic as possible. What is the defendant? What is he? In terms of if he were to go to a job and they were to say, do you have a criminal record, what would he say? What is his categorization by your office or by the state?
He could honestly say that he does not have a criminal conviction. If his potential...
I want to go back. Okay. So you're sitting at, let's say he wants to be a law enforcement officer, or you're sitting in an interview, and they ask you point blank, have you ever been convicted of a crime? His response would be exactly what?
His response would be no. For purposes of anything other than SORA registration, he has not been convicted of a crime. And he could honestly say that. He probably shouldn't say that if he's applying for a job with law enforcement, because they would have access to the law enforcement database, and they would be the only people who would be running a criminal background check who would see that he had a HIDTA.
The employer's next question is going to be, so let's just make clear, he has no criminal conviction, correct?
That's correct, Your Honor.
Okay, so the employer's next question is going to be, well, I'm confused, why are you on the SORA list? And his response would be what?
He would say that I pled guilty to, well, I would assume he would say I pled guilty to a sexual offense, a listed sexual offense, when I was 19 years old. And because the legislature thought it was a good idea to give youthful offenders a second chance, I was able to receive that plea and not have a conviction for any purposes other than sex offender registration. And the legislature decided that another noble goal that it was advancing was to protect the children of the state of Michigan from sex offenders sexually assaulting them. And they decided in this one limited, narrow category of HIDTA assignees, they would carve that out and they would weigh the balance in favor between these two important competing goals in favor of public safety. Offenders.
Counsel, can I ask you about not the plea agreement, but the agreement the court may or may not have made? I want to hear what you have to say about that on the sentencing date on March 4th or whatever it was. On that date, as I understand it, the court says, I'm putting you on HIDTA and these are the expectations I have for you, and if you do them, here are the benefits you're going to get from this bargain, and one of those is no conviction. What's your answer to the defendant's claim that that agreement, the agreement with the court about HIDTA, has been breached?
Justice McCormick, we don't know what the agreement with the court was. When the defendant pled guilty,
we know what the terms of HIDTA were. We know what the court said about what the benefits of HIDTA were that the defendant would receive, and one of them was no conviction and no civil disabilities, right? So why isn't this a breach when the defendant now has to be listed on a registry and as a convicted sex offender? Why isn't that a breach?
Well, Justice McCormick, with all due respect, the people disagree with your factual predicate. Will not suffer any civil disability.
So the fact that the statute says that, you don't agree with the defendant that the terms of the statute are incorporated by the court's agreement with the defendant to put him on HIDTA?
Your Honor, the people don't agree that there is an agreement with the court to put him on HIDTA. If the court had agreed, if the court or the prosecution had promised the defendant HIDTA, then there would be a breach. There would potentially be a breach. So when the court puts him on HIDTA, it's not promising him HIDTA? It's what? What is the court doing when it puts him on HIDTA? When the court assigns him to HIDTA, he has the expectation, if he successfully completes the conditions of his probation, that at the end of HIDTA, he will be discharged from HIDTA, and then he will not suffer civil disabilities as a result of his HIDTA assignment. And the people contend that those benefits do not ripen until the defendant has completed his end of the consideration. It's contingent.
But he did complete the terms of his probation, right?
He did, Your Honor.
And so if we think about no civil disability as attaching to the assignment to HIDTA, not the plea, it's an illusory promise, right? You're saying, well, you don't get a civil disability because of your assignment to HIDTA. You got it because you pled guilty. But if he had pled guilty and been convicted, he'd be on he'd have a civil disability. And so the promise of no civil disability, you're saying, was not, it was illusory, it wasn't worth anything, it wasn't a thing?
Counsel, what should the defendant have done if in this situation to avoid the circumstance that he's in? What should he have done differently?
If the defendant, if his plea truly was induced by the prospect of complete confidentiality and no civil disability, he should have moved to withdraw his guilty plea once he learned that he was going to have some of his information publicly accessible. Not all of it. Now, under SORA, the presumption...
So anybody that goes through a diversionary program, I guess, should be very concerned about this. I mean, basically, is it your office's contention that all these different diversionary programs for youth, that the person, if they're willing to go through them, can be put at risk, and that these programs really have no merit in terms of the fact that the promises that are made are basically meaningless?
Your Honor,
that's what I'm taking away, and I want you to see if you can correct my position right now, because otherwise your office is arguing a position that could basically put diversionary programs at risk, because why would I want to go through a diversionary program if this is the result that's going to happen?
Well,
Help me to understand why I'm wrong.
Well, Your Honor, the reason that the people believe that you're wrong and that the reason that diversionary programs are not at risk is that if a defendant is offered the prospect of a diversionary program and then the state does, and the state offers him that prospect and the defendant accepts it and successfully completes the terms of it, then he's going to receive the benefit of his bargain. And if he does not, then his remedy is to follow
this person successfully completed this program. It wasn't of any of his own volition that the legislature changed the terms in the middle of his program. He completed his side of the bargain. What part of the bargain did he not complete?
Your Honor, we're not saying that he didn't complete his part of the bargain, but the legislature can impose civil regulatory consequences on somebody after they commit a crime that are collateral consequences, as Justice Larson mentioned. And so that's what the people contend happened here. We're talking about an issue of fundamental fairness here. I think that's part of, that this seems unfair to some members of the court, that the defendant pled guilty to this, he performed his side of the bargain, he's not getting the benefit of the bargain. But the people contend that he is getting the benefit of the bargain.
Is it, but really, he's getting the benefit of the bargain. I mean, I just want you to think about your argument for a second. I don't mean to be disrespectful. Please don't take my tone as being disrespectful. But you're really making an argument that he's getting his benefit of the bargain. The whole reason he did this was to have a clean record. And now he did what he was supposed to do. How is he getting his end of the bargain where if he has to go on vacation or on a business trip, he has to register with law enforcement? I mean, he's going to do this for the rest of his life. I just think that I want you to really answer me and help me to understand how on earth is he possibly getting his end of the bargain with this situation that he's currently in based on circumstances that were beyond his control?
Justice Bernstein, first of all, we don't know what induced his promise.
Let me ask, all right, well, hold on. What induced his promise? Can we look at a common sense perspective, if that's okay? Is it fair to say that if you are basically on trial in a situation like this and you are facing the penalty that he is currently dealing with right now, which is massive registration, which is really something that affects your entire life, wouldn't it be fair that we could apply some common sense to this to say, wow, if I go into HIDA, then I complete this program and I do it successfully and I do what I'm asked to do, that this disappears from my record, there is no evidence of this, I can move forward with my life, I can answer no if I'm in a job interview, and I'm able to move forward. Wouldn't the HIDA in and of itself, forgetting any other facts, guilt or innocence or how you might feel, but couldn't the simple structure of the program, the way it is designed, the way it is implemented, be the kind of deal that anyone, if they're using any common sense, would say, this is something I'm going to sign up for?
Justice Bernstein, I think using common sense, if that is what induced the defendant's guilty plea, that when he learned while he was still on probation in 1997 that he would not have complete confidentiality, and that actually when he learned in 1994 that it would count as a conviction, and when he learned in 1997 that it would be open to public inspection at the police department, and when he learned in 1999 that it would be widely available on the internet, When he learned all that and did not seek to remedy that, then I think it's pretty fair to infer from that 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 is not what induced his promise, Your Honor. So using common sense.
Hold on, sorry. Using common sense, I just want to say that. So it's basically his responsibility to know of these types of changes. I mean, basically, it's one of the, I mean, I guess my question is, and I want to take it away from this case for just a second, that if I'm living my life and I'm doing my different things, that I need to know that the legislature is doing these different things. I mean, taking it away from this case, for any other circumstance, it is the responsibility of myself to know exactly what the legislature is doing at all times, and if I don't, I waive it?
There may be changes in the law that are going to happen in the future that will try to sort out this mess.